That's our logo. Can you see? Okay, so, you know, we've made some progress. Okay. So I think the adoption by the Cabinet of the National Anti-Corruption Strategy about 2 years ago. Okay, that's the first slide. No, I'm still on the first slide, Davey. Okay. As well as the appointment of the Council, affords us an opportunity to tackle the challenge of fighting corruption effectively by adopting a comprehensive, multidisciplinary approach. What we call an all society approach. So there's a paradigm shift that we have to engage with. We have to build upon, but go beyond the state capture by the Zupta framing of corruption, involving a small network of individuals. And the framing of the challenge of implementing an anti-corruption strategy by focusing exclusively on the very specific institutional recommendations of the Zondo Commission of Inquiry. So let me be clearly understood. I'm talking about building on its accomplishments, but at the same time recognizing that questions of institutional design and of institutional reform require careful, critical engagement. That is the approach we're adopting in the Council in examining our attitude to these very specific recommendations. For instance, the establishment of an independent and separate procurement agency, the establishment of a separate and independent whistleblower agency. I read the summary report produced by Perry last night. I want to congratulate Mungezi and Perry because it's an excellent report, and it does exactly that. It engages critically with the specific recommendations of the Zondo Commission. We need a response to the current patterns of corruption, state capture, Zupta, but also start to think broadly and strategically about corruption risks, including those not investigated by the Zondo Commission, and future risks. Because when you're thinking about institutions and radically transforming them, introducing new institutions, you want a future-proof strategy, not a snapshot approach to the fight against corruption. So what do I mean by the paradigm shift? The National Anti-Corruption Strategy, and many of you here were involved in developing that strategy, wasn't developed top-down by government. It drew on the best expertise available in the country. So it has 6 pillars. We have to look at, in thinking about implementing an anti-corruption strategy, at all 6 pillars. That's what we mean by a multidisciplinary approach. Think, if you like, about even a challenge of fighting crime. we understand that fighting crime requires a comprehensive set of responses that focuses on law enforcement and prevention, behavior change. So what are the 6 pillars? They're there. Most of you are actually familiar with them. Promote and encourage active citizenry, number 1. Advance the professionalization of employees in the workplace. Enhance governance and accountability in all sectors. Improve integrity, transparency, and credibility of the procurement system. Strengthen the resourcing, coordination, performance, accountability, and independence of dedicated anti-corruption agencies, and protect the vulnerable sectors that are prone to corruption. 6 pillars. The Council is focused on all 6. So what kind of body is the NECAC? I want to talk about this because I think our role is not widely understood. I mean, at least in the public domain. We are an advisory body made up mainly of people who are appointed because of their expertise or their role in civil society. We have 6 work streams. Whistleblowing, and the Chief Justice says we should focus on whistleblowing. We agree. So we are focusing on whistleblowing. That work stream is headed by Thandeka Kubula Mbeki. The procurement work stream, again, another focus area, is headed by Advocate Khumalo. Procurement monitoring and evaluation by Sikotlani Pamodi. Communications by our Deputy Chair. Legislation and transparency by Kavisha Pillay. And the anti-corruption architecture, which in some sense spans the work of the Council, is headed by Dave Lewis, who's sitting in front of me. And I believe many of the members of the Council participated yesterday. Those working groups are working very hard. They all have reference groups, and many of the experts in the field of fighting corruption have been incorporated into these reference groups. I see Professor Claren there, but many of you are involved in those reference groups. We are making sure that in our approach, we are bringing in the anti-corruption community to work with government to design interventions that are likely to work. Once we were appointed, we realized that the implementation of this strategy that was adopted by the Cabinet 2 years ago has to be an iterative one, by which I mean 2 things at least. One is that although we are appointed by the President to advise as an independent body, and we are protecting that independence, we will advise the President based on our evidence and our thinking. But it's an iterative process because implementing this comprehensive all-government approach requires us to work with many government departments. The Department of Justice, obviously, but the Department of Education, because as you might have heard yesterday, I didn't hear the presentations. I don't know what the DG reported, but I see Jonathan Sims is here. The government, the implementation of the Zondo Commission recommendations and the implementation of this strategy, in my view, is being taken seriously by the government. The DG has invited the Council to participate in the DG's forum, precisely because we have an overlapping mandate. If we're considering whistleblowing, and questions of institutional design, so is the Department of Justice. So we have to make sure that we're in a dialogue with them, and that in considering various steps that have to be taken in the process of implementing the strategy, obviously we have to be working with all the departments while protecting our independence. And so the decision of the Director General of the national government to involve the council was, to us, an indication that our role is valued and that the government is taking the implementation of the strategy seriously. That doesn't, we have had many points where it appears that processes are protracted. We have, we are not, I mean, we have been constrained by a lack of resources, but we are not preoccupied with our constraints. We are trying to tackle this challenge, and I can tell you that this council is, and the people on it are committed to this fight. And we've had the privilege of encountering many people in government, and particularly the heads of the law enforcement agencies who are on our side, who are part of the fight against corruption. Now, the way we think about remedies for corruption depends on how we conceptualize corruption. And I think that that is a conversation we should not take for granted. Because we use this concept in a taken for grantedness way, as if we all mean the same thing. I am going to delineate schematically two ways of thinking about corruption and its remedies. Both are correct, but one is too narrow. And the one that is too narrow dominates the public discourse. So what is the way of thinking about corruption which is too narrow? To reinforce the point I'm trying to make, that the adoption of a multidisciplinary and comprehensive strategy and the appointment of this council helps us to think differently, more broadly, more strategically about the fight against corruption. So what is the narrow approach? It focuses, let's call it, as I say, a famous judge also, Judge Krickler, sitting in the audience. So it's the juridical approach. It reduces corruption to the conceptualization of corruption and the remedies for corruption within a legal and legalistic paradigm. It equates corruption with illegal actions like bribery, what could be called in the literature quid pro quo corruption, and fraud, for which the proper remedy is indeed after the fact investigation and prosecution of individual acts of criminal malfeasance. So the focus that this approach leads you to is mainly to the misconduct of administrators and politicians. It is also punitive. What it emphasizes is the punishment of individuals. And so it's not surprising if you're thinking in these terms, you'll come to the conclusion that the remedy for fighting corruption is to establish a single anti-corruption agency which has a monopoly of prosecutorial and investigative powers. What this leaves out is what paradoxically you could call legal corruption, corruption that isn't identified in the law like PRECA, institutional corruption, which the Zondo Commission's evidence led it to, hence its focus on procurement, and what I'm going to call systemic corruption. Systemic corruption is an issue, is a concept that we're beginning to debate in the Council, but we're at the early stages. As far as I'm aware, IPID is legislation that incorporates this concept, but nobody has been able to define it. And maybe it's not a concept that can be defined in law. And it dominates. This is the perspective that dominates public discourse. Now, of course, we have to ensure that we improve investigation and prosecution of criminals in our fight against corruption. And so the focus on the role of the NPA, the SIU, the ID, and so forth is critically important, but it's not enough. What is the broad approach? The broad approach recognizes, and you can see why a council like ours would be adopting a broad approach, recognizes the diversity of corruption problems. Not all forms of corruption are illegal. It can include forms of nepotism, collusion between private sector agents in the procurement process, like price fixing, conflicts of interest, raising perhaps ethical questions, the capture of policy-making processes, regulatory processes, democratic political processes. Much of the avenue for that is the private funding of political parties. What is destroying democracy in the United States. We have to be able to look at the United States and saying we're going to prevent that from happening here, although I think we're already well along that path in South Africa. Institutional corruption. Institutional corruption breaks from this individualistic, legalistic paradigm. The evidence before the Zondo Commission led them to think about patterns, networks. So we started in the Council a debate on systemic corruption. I would encourage a book that I'm just starting to, or reading, which identifies 4 syndromes of systemic corruption. I think South Africa incorporates all these elements. But the one element that we haven't had a focus on, and where I think respectfully the Zondo Commission was in a sense under-inclusive, was a focus on what this author calls influence markets. The intersection between the private sector and the public sector, in the way in which wealth and power is accumulated. So a comprehensive, one other point, we also need to be aware of the informal norms that underpin corruption practices in organizations. So if there are these informal norms that are difficult to reach, they're difficult to reach by the law, by a exclusive focus on procedures. If we're going to tackle corruption, then we have to be aware about what's going on in our society, what norms as outside of the law shape behavior, and have strategies to deal with what could be called kind of the normative structures which support corruption in our society. So a comprehensive, multidisciplinary approach adopts a wider set of remedies to address corruption challenges. So corruption includes public and private collusion. It includes individual criminal acts, but we also need to look at institutional and systemic forms of corruption. Certainly, state capture involved the abuse of public power by a network of highly placed administrators and politicians, acting not, the definition is that they were acting for their private purposes. That's the accepted definition. But really what this was about was the enrichment and accumulation of wealth and power in our society in ways that are improper because they undermine democracy. But state capture also included a network of enablers, accountants, lawyers, as well as private organizations, numerous corporations, some incorporated in multiple jurisdictions, banks, large consultancies with accounting practices, engaged in collusive dealings with the state, who were apparently among the primary beneficiaries of state capture. So look at the evidence before the Zondo Commission. And so I think Paul Holden was right to say in his recent book that this was a matter that didn't receive sufficient attention in the Commission. Now, that's not a criticism of the Commission. The Commission was bound by its terms of reference, and it was a judicial commission of inquiry. Now, Pillar 5 has got to do with looking at the institutional architecture. David heads up that work stream. The way we are approaching that question is concretely and bottom up. We're not simply looking at the comparative experience, because we have to understand the institutional map, the institutional infrastructure of anti-corruption institutions that already exist. Now, I don't know if you can see that. Law enforcement agencies, we have the MPA, the DPCI, the AFU, the South African Police Service, Crime Intelligence, and IPID. On prevention side, we have the SIU and various departments. On the coordination side, we've had some success with the Fusion Center. They did excellent work on COVID. But the institutions that were set up, the ACTT, which has now been replaced for coordination purposes, was, I think most people would accept, was a failure and was only recently replaced. Then we have intelligence gathering agencies, the FIC, the South African Revenue Services, the Auditor General, SAMLET, that deals with money laundering, the South African Reserve Bank. When it comes to discipline and ethics, we've got the PSC and the DPCSA. And on procurement, and then the Zondo Commission has made a recommendation for 3 new institutions. Frankly, without adequate evidence, without the proper process of inquiry to come to those conclusions. Procurement, whistleblowing, all separate institutions, and a permanent judicial commission of inquiry. Now, what I want to stress here is, how do you think about introducing a new anti-corruption institution, designing, we have in place a multi-agency framework for fighting corruption in place. They all consume resources. They all, in some sense, have their own mandates. They have their own interests. I don't mean illegitimate interests. So the task of introducing new institutions and redesigning them requires a proper methodological approach to arrive at conclusions, setting up new institutions that can work. Justice Krichler would have played a prominent role in the process of redesigning our political institutions when we adopted our new constitution. How thorough, how careful, how considered were we in approaching that project? we are in a period 30 years later where we, in effect, are having to rethink comprehensively our political and perhaps even our economic arrangements. We have to be as considered, as thoughtful, as careful. The Zondo Commission made a recommendation that we now need an elected president to fight corruption. Well, there's a lot of literature which suggests that that's precisely what we shouldn't be doing in a jurisdiction like ours. Now, the point is simply to stress that, almost done, that this is what we've got to undertake. So, there are some critical questions of institutional design, which I'm going to list, some of them, that we're considering in our work stream. I am not, I think it wouldn't be correct to, we are close to a consensus on some of the critical parameters of a new institution. We're close to parameters. We're planning to report next year, but I want to make sure that we reach complete consensus supported by evidence before we come to conclusions to share publicly, because we haven't even communicated our views to the President as yet. But what are the questions that we are considering? And that should give you some signposting about where we're going. We've started with what the main functional gaps are in the current institutional matrix. Institutional corruption, which the Zondo Commission does try and address. Policy making, including monitoring and evaluation, and citizen participation. It's not there yet in the current institutional matrix. A new anti-corruption institution is probably needed to focus on prevention and it should have powers of proactive, as opposed to after the fact, proactive investigation into institutional corruption, something like procurement. And so possibly a new institution, anti-corruption body, will include an institutional capacity to deal with procurement corruption. If this new body has investigative powers, the challenge is going to be to define its scope, because any decision we make in this regard is going to have an impact on the investigative powers of other existing agencies. We have to think about that, not behave like a wrecking ball. So we probably are not going to recommend the establishment of an institution, new anti-corruption institution, which has a monopoly of prosecution and investigative powers, and which combines prevention and punishment. And I'm going to explain a little bit in my next slide why. Should the new anti-corruption agency have a mandate to deal with conflicts of interest? It's not all conflicts of interest which are corrupt are illegal. And I know, talk to a lot of politicians. They think that when there are conflicts of interest, it's not illegal, then there's no problem. But there's a big problem with conflicts of interest in a society like ours. Next, what should the legal form be of any new institution if such an institution is established? Should it be a statutory body or a constitutional body? We have not resolved this question. I have my own views, which I'm Since David is here, I'm not going to articulate publicly. Oh, well, it doesn't really matter. I mean, we're having a debate. I think it should be a body. I'm almost done. Next, the challenge of coordination, effective coordination. That's not only an architecture problem, it's also a problem of institutional culture. So this is my last slide. I think we're in a period now where we have to move from anti-corruption policy to thinking about how to implement an anti-corruption strategy effectively. And the international evidence is that to achieve results is over the long term, with a comprehensive, to deal with corruption comprehensively, the results are not emphatically positive. It's a huge challenge. It's a long-term challenge. So, avoid a simple borrowing of a toolkit from a supposed global consensus. How often do we do that? Next, adapt your anti-corruption responses to specific anti-corruption problems and institutional conditions in your own society. Prioritize and sequence critical interventions incrementally, like public sector reform or procurement reform or whistleblower protection. Next, recognize that there is no panacea or quick fix. Next, avoid giving too much importance to short-term solutions, orange overalls. That's how we judge the conviction rate. That's how we judge whether we're making progress. But in a high corruption situation like ours, prioritize the strengthening of investigation and prosecution capabilities. So I'm not arguing that we shouldn't be looking to the NPA, the ID, the SIU, and the DPCI not to get better results in the investigation and prosecution of criminals. Whoever they are, the higher they rise, the harder they should fall. Do not assume that corruption problems are the same everywhere. We have to understand, have a fine-grained understanding of corruption in South Africa. Avoid an overemphasis on reform from above over contestation and mobilization from below. Build a base of support politically. A new agency should have a role, a specific role in public education, public mobilization, and public participation. And that's why it would not be compatible with the inclusion of prosecutorial powers which require confidentiality, objectivity, and impartiality. Next, link implementation of anti-corruption strategies to citizen well-being, the improvement of services, health services, systems of policing, and so forth. Tembisa hospital is a very good example. Let's not go to Tembisa and say, let's fight corruption. Let's fight corruption by improving their health services. Finally, understand anti-corruption as an issue of fundamental justice, implicating the way we are governed and the fairness and inclusivity of our political and economic institutions. It's not simply, it is, but it's not simply a problem of individual immorality and criminality. So we should not avoid moral discourse. But we need a wider approach, one that is more likely to win in the long term, more likely to mobilize our people in this fight, because those are some of the essential ingredients of a successful anti-corruption strategy, which may take us 10 years, 20 years, but we will win this fight if we do the right things, and we must win this fight, as Justice Zondo was saying, because it's an existential one. We did not fight to live in a corrupt society. We fought for a just constitutional democracy. That's what this fight is about. Thanks very much.